The Senzo Meyiwa murder trial is ongoing at the Pretoria High Court, or the High Court sitting in Pretoria. First state witness Zandile Khumalo has wrapped up her testimony. Defense counsel for accused number 5, Advocate Zandile Mshololo, has accused Khumalo of fabricating evidence after she failed to describe the clothes worn by the second suspect. Thabo Masombuka is a legal analyst and he joins us now to take a look at developments so far around that case. Thank you very much for your time this afternoon. Perhaps let's start with whether the defense managed to plant that seed of doubt in the judge's mind that this witness is not telling the truth, because theirs is to make sure that the people they're representing do not take the rap for something that they did not do, which is what they are saying, that these 5 men did not do this.
Yes, thanks. Thanks to you and your viewers at home. I think you're correct. The responsibility of defense counsel in any criminal trial is not to help the state prove its case, but just to establish the existence of a reasonable doubt. In fact, they just need to, create doubt by pinching the holes in the state case, either through credibility or through consistency or through the reliability of version. And what we have seen with the first state witness already, all defense counsel try to say, you are fabricating evidence, you can't remember what happened there, you probably are trying to hide out the truth. Remember, the purpose of a criminal trial is not about the competition of the state and the defense, it's about establishing the truth of what happened on the day in question. So we still a long road to go. But what is important and what viewers need to understand about this set or this version of the trial, remember it has started de novo, is that it will be important for the state to call into the testimony, onto the stands, all persons who were there on that day. To call these other people who, I heard this one say that, it's not going to be helpful to their case. They all need to just call all the people who were there on the day in question to tell what they remember, so that the court can make a determination on what actually happened there.
Okay, let's take a listen at this, because this is not the first time the judge has also I don't know if lash is a good word, but it's a strong word. So maybe has guided the defense counsel, for lack of a better expression, in terms of the line of questioning. Let's take a listen at what he said today.
But what also deludes me, the neighbors, didn't they see anybody running along the street, either up or down?
Okunye futhi nje okungihluphayo ukuthi omakhelwane akekho nje umuntu abambona egijima ngomgwaqo noma ehla noma ekhuphuka ngawo umgwaqo.
My lord, engikholelwa ikhona ukuthi
you mustn't tell me what they told you.
Cha. Engikholelwa ikhona ukuthi bakhona omakhelwane ababathathe amaphoyisa athathe statement zabo ukuthi zithini angikho sure.
What I believe in, my lord, what I know is that there are neighbors from whom the police took statements. As to what is contained or what they said in those statements, I don't know.
Because it's amazing, in the location, the person just vanishes. No. Just that, not even one person who said, I saw somebody jumping a fence, ebokaya, or that type of thing. Nobody saw anything.
Okay.
I believe that those who saw in a particular way, but their statements haven't been read out here in court.
Okay.
When you speak of calling only the people that were in the house, is that not a fair assessment that someone somewhere must have seen something?
Yeah, whether someone somewhere saw anything is quite frankly secondary and immaterial to the real charge on who made that sense. Because the only person who can tell who killed or inflicted the wound that led to the death of Senzo Meyiwa is someone who was in the house. What the judge is trying to gather and corroborate there is to say, in the broader scheme of things, what is the totality of evidence that helps us understand what happened on that day? And I think that is where the state, and I heard that they were trying to, the second witness was initially on the 28th list, in the list, number 28 on the list, I am not sure if they really want to call all these other witnesses, quite frankly, for all intents and purposes, because the real people who remember and who knows and who saw who killed Senzo are people who were in the house. Zandile is one of them. Kelly Kumalo is one of them. The mother of Kelly is one of them. Longwe, that Longwe guy is one of them. So it would help their case if they really limit their witness list to those who are going to help the court establish the materiality of the evidence. This thing of calling secondary witnesses, third version witnesses, is quite frankly, there are 5 defense counsel there. 5. So each of them must cross-examine. So we're talking another 6, 8, 9, 12 months in this trial. That's a justice delayed for the family.
I mean, also the judge has been at pains to point out whether through actions or words to say that enough time has been spent on this, so we need to get justice. Do you see that happening? Are we likely to see the state shortening the number of witnesses that they're going to call from that 28 to maybe 6 and limiting it to the people that were in the house, including the witness that we're going to see in the next hour, the neighbor?
Yes, quite frankly, it's in their interest to really summarize their version and the list of their witnesses to establish the materiality of the evidence. If you look at this judge compared to a previous judge, he's a relatively an active judge in establishing the pattern of cross-examination, of leading evidence. His role there is to make sure that the rules of leading evidence is followed to the letter. And I think it's been at pains even, I mean, if you look at the instances where he had to question Advocate Mshololo to say, what is the relevance of that statement? Is it hearsay? If it's hearsay, what are the rules of evidence, evidentiary rules and the burden of evidence? Because you can't be leading, hearsay evidence unless the person who made that statement is going to be called on. But the question again is, how relevant is the testimony of that person to the main charge? And the charge here is murder. And who committed the murder. So it's going to be a bumpy road for the state, but I think that this new evidence, this new trial, in fact, has provided them an opportunity to do what is called the reawakening. If you recall the previous trial, they started, quite frankly, on a wrong footing. They started calling police who arrived late on scene. They called a lot of captains and investigation officers who had from witnesses who were on the scene. So they actually started on a wrong footing. I think they got a rude awakening. Somebody said to them, listen, advocate for the state, focus on the real matters, call the real witnesses who were there, who were physical on the, let them try to establish, paint a picture before the court. Because the court is interested in a picture of what happened there. Then the other witnesses who come here can come just to corroborate the initial version. But the primary version are those who were eyewitnesses to the incident.
Does the character of a witness matter in making a determination on the part of the judge? For instance, this morning he had to, on the part of both the defense and the witness, say, well, let's maintain the decorum of the court. Because yesterday, Zandile Kumalo going into it with one of the defense counsels, going as far as saying, I'm not your wife, watch your tone when you speak to me, etc. Does the character of the witness matter?
The character of the witness in establishing what he or she knows in a trial, even if it's a complainant, really doesn't matter. If you want to bring it as evidence, then you have to apply to bring it. I'll make you an example. I don't know if your viewers will remember. When former President Jacob Zuma was charged for rape, right? He went to trial for rape. Well, no one ever saw the complainant. But if you look at the pattern of the defense strategy, they applied to bring in what is called character evidence of the complainant based on what she had said in Swaziland some years ago. Now, that's called character evidence. The judge had to make them apply and give reasons why that evidence is critical and relevant. So evidence relating to character of a person or a witness in a criminal trial is not necessarily relevant unless you can bring an application to demonstrate that there's a consistent pattern in this character, and this pattern is relevant to the particular charge that the accused persons are facing.
You mentioned that it would be in the best interest of the state's case to whittle down that long list of 28 to just the people that were in the house. What mechanisms can the court use to compel the state to do so in the interest of saving time?
Look, the court and the judicial officer sitting there is actually the ultimate decider of what direction this trial needs to take. Although the state is what is called dominus litis, meaning they are the commencer and the ender of legal proceedings in any criminal trial. However, in the interest of justice, the court can. It has the discretion. For instance, I already heard that they are not interested in calling Kelly Khumalo, for an example. But here's the thing. How do you establish the completeness of the truth without the testimony of Kelly Khumalo, after she was the person who was in the house, who was also involved in the so-called love triangle? Because already the judge has already established that based on the evidence presented before him, there was indeed a love triangle here. At the center of two women was a man who's deceased, who can't talk to himself or for himself. So if the state decides to withdraw Kelly or not call Kelly, the judge can, in the interest of justice and in the interest of the truth and in the interest of the completeness of the version, call in Kelly to say, you need to tell us about your participation on that day, what you saw and what you didn't see. And that is important for what is called the completeness of the truth, because the judge was not there, me and you were not there, observers were not there, the family was not there of Senzo, but all we need the truth. And if there are mechanisms or there are measures or there are attempts to conceal the truth by not calling certain witnesses, it is in the interest of justice that the judge will step in and say, hold on, I need that witness to come and tell the court what he or she remembers on that particular day.
You speak of the interest of justice, not just on the part of the Meyiwa family. Perhaps this may be premature, but family members of some of these men have expressly said that these are not the people that are involved in this crime. What happens in the event that these men are found innocent of this particular crime after so many years?
Look, any person charged in South Africa wrongfully or unlawfully, and once the court has established that there was no basis. Remember the court in its judgment. Somebody asked me about the character of witnesses, for an example. Can the court condemn the character and the attitude? I said, no. What the court will do in its delivery of judgment, it will go blow by blow on the evidence of each witness and discuss how their behavior, their demeanor, their body language, whether or not it was helpful to establish the truth. And if it does appear at the end of the trial that the state was doing what is called a fishing expedition, in other words, they were just throwing a net, hoping that they will come up with fishes, who fishes are the 5 men seated there, then once the fishing expedition theory is established, then these families have got what is called the legal basis to sue not just the Minister of Police, but they must also establish the causal nexus between the actions of the police and that of the what is called the prosecution, who, by the way, always have a discretion to decide whether or not to proceed with criminal trial based on the evidence. So if they seated with the testimony and the version should not have reasonably proceeded with this case, and the judge arrived at the conclusion that, guys, not only were these men not supposed to be charged, but there was not a basis upon which a reasonable court could convict, then the families of those guys have got the basis to actually take the matter up on a civil court of law to claim redress.
Thank you very much for your time this afternoon. Thabo Masombuka is a legal analyst.